Welcome back to U.S. Visa Updates, your trusted source for the latest developments in American immigration. Before we dive into today's critical updates, I want you to ask yourself something. Have you checked your case status this week? Have you noticed any unexpected changes? Because what happened in the immigration system over these past few days might directly affect your journey to the United States. And staying informed could be the difference between moving forward and being left behind. If you're waiting on a green card, renewing your work permit, or planning to travel internationally, the next few minutes could change everything you thought you knew about your timeline. So, stick with me until the end because I'm going to share some crucial insights that most people are missing right now. Let me start by painting the picture of where we are right now in December 2025. The immigration landscape in America is not frozen, it's not stagnant, and it's definitely not predictable. What we're seeing is something I can only describe as cautious momentum. Things are moving, cases are being processed, decisions are being made, but everything is happening within a framework that demands precision, preparation, and patience. This isn't the wild uncertainty we saw in previous years, nor is it the smooth sailing that applicants might hope for. It's something in between. A carefully managed system where progress is possible, but only for those who understand how to navigate it correctly. Throughout this entire month of December, we've witnessed a pattern that keeps repeating itself. Immigration updates aren't coming from just one direction anymore. They're arriving from multiple agencies simultaneously, each operating on its own timeline, each with its own priorities. Families who have been waiting months or even years for their green cards are suddenly seeing movement they didn't expect. Workers who depend on employment authorization documents to maintain their livelihoods are anxiously watching their mailboxes and online case statuses. Meanwhile, visa applicants overseas are dealing with embassy schedules that seem to shift from week to week, sometimes improving, sometimes creating new obstacles. And hovering over all of this are ongoing conversations about travel restrictions, enforcement priorities, and policy adjustments that could reshape the entire system. What makes this week particularly significant is that we're not dealing with speculation anymore. These aren't rumors floating around immigration forums or unverified stories shared on social media. What I'm sharing with you today is based on confirmed public information, official agency activity, and reports from immigration attorneys who are in the trenches every single day, helping real people with real cases. So when I tell you that something is happening in the system, you can trust that this information is as solid as it gets in the ever-changing world of immigration news. Now let's talk about what actually happened this week. Starting with the United States Citizenship and Immigration Services, better known as USCIS. If you have a family-based green card application pending, you need to pay very close attention to what I'm about to tell you. This week began with noticeable activity inside USCIS processing centers, particularly for family-based cases. We're talking about applicants who had been sitting in what felt like an endless waiting period. People who had almost given up hope of seeing any progress before the new year. These individuals started reporting significant updates on their case statuses. Some saw their cases move into active review status. Others received notices that their interviews were being scheduled, and in what can only be described as early holiday miracles for some families, actual approvals started coming through. Immigration attorneys across the country are telling us that they believe USCIS is making a concentrated end-of-year push to reduce older backlogs before the agency fully transitions into 2026 procedures. This is significant because it suggests that USCIS leadership recognizes the mounting pressure from these long pending cases and is actively trying to clear them out. However, and this is important, this movement has not been uniform. Not everyone is seeing progress at the same rate. The improvements are happening across different case types and different service centers, but they're not affecting every single applicant equally. Some people are experiencing dramatic forward movement, while others in seemingly similar situations are still waiting without any updates. What's really interesting about this development is what it tells us about USCIS's current operational philosophy. The agency appears to be making a deliberate choice to provide relief to families who were genuinely concerned that their cases would remain completely stalled through the new year. This suggests a level of awareness about the human impact of these delays, which is somewhat encouraging, but at the same time, USCIS is not simply rubber stamping everything that comes across their desks. Far from it. In fact, what we're seeing alongside this movement is something that might concern some applicants. USCIS has continued and arguably intensified its application of stricter intake and review standards. What does this mean in practical terms? It means that applications with even minor problems are being denied more quickly than we saw in previous years. We're talking about cases with missing signatures, applications submitted on outdated forms that should have been updated, or cases with inconsistent financial evidence that doesn't quite add up. These applications are being rejected faster than ever before. This reflects what appears to be a deliberate policy direction focused on making faster decisions, but with significantly less tolerance for errors or incomplete submissions. Now, this approach has created what I would call a two-tier reality within the system. On one hand, well-prepared cases, applications that are complete, accurate, and properly documented are moving through the system more efficiently than they have in years. Applicants who took the time to double-check everything, who consulted with qualified immigration attorneys, who made sure every single document was in order. These people are benefiting from this new approach. They're seeing reduced processing times and getting their approvals without the lengthy delays that characterized the system in previous years. But on the other hand, applicants who rushed their filings, who tried to cut corners, who relied on incomplete documentation or outdated advice from non-professional sources, these individuals are facing swift denials and having to start over. The message from USCIS this week has been absolutely consistent and crystal clear. Preparation matters, attention to detail matters. Following instructions exactly as written matters. This is not a system that's going to give you the benefit of the doubt anymore. This is not a system where you can submit something that's almost right and hope they'll work with you to fix it. The current environment demands precision, and if you can't meet that standard, you're going to face consequences. Moving beyond family-based cases, let's talk about employment-based green card processing, which showed what I would describe as mixed but meaningful movement this week. Some applicants, particularly those in categories that were already close to current, according to the visa bulletin, saw genuine progress toward final adjudication. These are people who have been waiting for their priority dates to become current. And once that happened, USCIS actually moved forward with processing their cases rather than letting them sit in another queue for months. This is actually a significant improvement compared to what we saw earlier in the year, when cases would languish even after priority dates became current. However, and this is a big however, other applicants, particularly those in heavily backlogged employment-based categories, saw little to no change this week. This isn't because USCIS doesn't want to process their cases. It's because of visa number limitations that are completely beyond the agency's control. These are statutory limits set by Congress, and until those laws change, there are only so many visas available each year for certain categories. So even if USCIS wanted to approve every single employment-based green card application tomorrow, they literally cannot do so because the visa numbers simply don't exist. What stood out to immigration professionals this week was USCIS's continued commitment to processing cases more decisively once priority dates actually become current. This is reducing those frustrating waiting periods between filing and final action that drove applicants crazy earlier in the year. If your priority date is current and your case is properly prepared, you have a much better chance now of seeing timely action than you did 6 or 8 months ago. That's real progress, even if it doesn't help everyone equally. Now let's shift gears and talk about work permits, because this is where we got some of the most positive news this week. Many applicants who have been waiting for employment authorization document renewals or initial approvals reported significantly faster turnaround times. This is particularly true for people whose EAD applications are connected to adjustment of status filings or certain humanitarian categories. What appears to be happening is that USCIS has made a strategic decision to reallocate internal resources specifically to prevent a large number of work permits from expiring right at the end of the year. Think about what this means for the thousands of workers and families who were staring down the possibility of losing employment authorization during the holiday season. For many of these individuals, an expired EAD doesn't just mean an inconvenience. It means potential job loss. It means inability to pay rent or mortgages. It means financial disruption at exactly the time of year when expenses tend to be highest. The fact that USCIS appears to have recognized this risk and taken proactive steps to address it is significant. This represents a meaningful relief for people who were genuinely worried about their economic survival. It's exactly the kind of forward-thinking operational decision that we hope to see more of from immigration agencies. Turning our attention overseas, visa processing at embassies and consulates remained uneven this week, but there were definite signs of gradual improvement in certain areas. At the National Visa Center, which serves as the central processing point for immigrant visa cases before they go to embassies, document review times have continued to shorten. This is allowing more cases to reach what's called documentarily qualified status, which is essentially the green light that means your paperwork is complete and your case can move forward to the interview stage. Several applicants reported receiving updates after experiencing long periods of complete silence, which suggests that NVC is working through its backlog more effectively than it was earlier in the year. However, and this is where things get complicated, consular interview availability continues to vary dramatically by country. Some embassies have expanded their appointment slots, bringing in additional staff, or extending operating hours to accommodate more applicants. Other embassies remain severely constrained by staffing limitations, security requirements, or local conditions that limit their capacity. What this means in practical terms is that while your paperwork might be moving faster through the NVC, you could still face significant delays when it comes time to actually schedule your interview. Interview scheduling remains one of the single largest bottlenecks for families waiting overseas, and this hasn't really improved as much as other parts of the process. This week also brought renewed attention to something that makes many immigrants and their families understandably nervous: enforcement activity and coordination between immigration agencies. Based on publicly reported cases and official statements, we can confirm that Immigration and Customs Enforcement, known as ICE, continues to conduct targeted interior enforcement operations. These operations are focusing on individuals with final orders of removal, people with significant immigration violations on their records or cases that have been flagged through shared data systems between agencies. Now, I want to be very clear about something because there's a lot of fear and misinformation circulating about this topic. Lawful permanent residents and applicants with clean records are not the primary targets of these enforcement operations. If you're maintaining lawful status, if you're following the rules, if you're showing up to your immigration appointments and court dates, you are not the focus of current enforcement priorities. However, the overall enforcement environment does feel more visible and more structured than it did in some previous periods. Community advocates have noted that increased enforcement presence can create fear and anxiety even among people who are pursuing completely lawful status and have nothing to worry about legally. This psychological impact is real and shouldn't be dismissed. When people see increased enforcement activity in their communities, even if they personally have nothing to fear, it can affect their willingness to engage with the immigration system, to attend appointments, or to travel. This creates its own set of challenges for families trying to navigate an already complex process. Travel concerns also resurfaced this week in a significant way. Now, before anyone panics, let me be clear about what we know and what we don't know. No new travel ban has been officially announced this week. There has been no executive order issued restricting travel from specific countries. However, discussions around national security reviews and enhanced travel screening procedures continue at the federal level. Multiple federal agencies have confirmed that enhanced screening procedures remain in place at ports of entry, particularly for travelers arriving from regions that are under active security review. For right now, green card holders and valid visa holders are not subject to any new restrictions. If you have a valid green card or a valid visa, you should still be able to travel and return to the United States. However, and this is important for anyone planning to travel, many travelers are reporting longer questioning periods at ports of entry and more frequent referrals to secondary inspection. These secondary inspections are not necessarily an indication that anything is wrong with your case. Often they're simply part of enhanced screening protocols, but they do take time. They can be stressful and they can delay your entry into the country. Immigration experts are strongly advising travelers during this period to carry complete documentation with them. Don't just bring your passport and visa or green card, bring evidence of your ties to the United States, evidence of your employment or studies, letters from your employer, anything that demonstrates your legitimate purpose for entering the country. The more documentation you have available, the smoother your entry process is likely to be. And perhaps most importantly, stay informed. Immigration policies and screening procedures can change quickly, and what's true today might be different next week. The visa bulletin continues to be one of the key factors shaping expectations for everyone in the immigration process. This week's discussions and analysis around the visa bulletin didn't include any dramatic changes or major surprises, but the stability itself was actually significant. Family-based categories managed to avoid retrogression, which is when dates move backwards. Some employment-based categories held their ground or even moved slightly forward. Immigration analysts believe this cautious approach reflects a deliberate effort by the State Department and USCIS to manage demand carefully and prevent sudden disruptions as we move into early 2026. While this cautious approach means that progress may feel painfully slow for those waiting, it also significantly reduces the risk of abrupt setbacks. There's nothing worse than seeing your priority date finally become current only to have it retrogress backwards the following month, putting you back into waiting mode. The stability we're seeing now, even if it means slower forward movement, is preferable to that kind of volatility. Another important development this week that hasn't gotten enough attention is increased transparency from USCIS regarding its processing approach and decision-making behavior. Agency updates have emphasized something that I think every applicant needs to understand. Faster decisions do not automatically mean more approvals. What they actually reflect is a philosophical shift toward providing clear outcomes, whether those outcomes are positive or negative. USCIS is approving cases that are complete and meet all requirements, and they're denying cases that don't meet requirements, and they're doing both of these things faster than before. This new clarity, while it might feel challenging or even harsh to some applicants, actually provides significant benefits. It allows applicants and their attorneys to make informed decisions about their next steps rather than waiting indefinitely in limbo for responses that might never come. If your case gets denied, obviously that's disappointing, but at least you know where you stand and you can decide whether to refile, appeal, or pursue alternative options. The previous system, where cases would sit in pending status for years with no indication of whether they would ultimately be approved or denied, was arguably worse than getting a quick denial, because at least a quick denial gives you information you can act on. Court activity also remains highly relevant to the immigration landscape, even though it doesn't generate daily headlines. Several immigration-related cases continue moving through the federal court system, including important matters involving enforcement authority, procedural protections for applicants, and the scope of agency discretion. While no major Supreme Court decision was issued this week that directly affects green card or visa processing, the ongoing litigation continues to shape the legal boundaries within which immigration policies are implemented and enforced. These cases contribute to the broader environment and can have significant impacts down the road, even if their effects aren't immediately visible. As this week comes to a close and we look at the overall picture, I would describe the situation as complex, but not bleak. Immigration in December 2025 is characterized by cautious progress rather than dramatic transformation. Some applicants are seeing long awaited movement in their cases and experiencing genuine relief. Others continue waiting due to structural limitations like visa caps, consular capacity constraints, or priority date backlogs that no amount of efficient processing can overcome. Enforcement remains present and visible, but appears to remain targeted rather than indiscriminate. Travel policies remain under active review and discussion rather than expansion into new restrictions. For immigrants and their families, the most important takeaway from everything that happened this week is the critical importance of awareness and preparation. Monitoring your case status regularly, responding promptly to any requests from USCIS or other agencies, and ensuring that your filings are accurate